For joining us today, and welcome to our presentation on digital asset regulation on both sides of the Atlantic, where we are going to discuss and contrast regulations in the US and EU for digital assets. This presentation is a cross-office collaboration between Kramer-Levin's Silicon Valley office and our Paris office. I'm Chris Castens, a partner in the Silicon Valley office. Joining me today are my colleagues from Kramer-Levin's Paris office. Can you guys go ahead and introduce yourselves quickly?
Yeah, a few words. Thank you, Chris. I am Hubert from the Paris office. I'm partner with Morgan and Victor. Morgan?
Morgan, nice to meet you. I've been working previously at Ledger, and I am with Victor also.
Victor?
Yes, my name is Victor Champiat. I'm a lawyer at the Paris Bar, and I work almost exclusively on digital assets regulation.
Thank you. Today, we want to discuss how the US and EU have diverged in their regulation of digital assets. We will describe and comment on the ongoing regulatory efforts in the US and EU, and we will try to keep this as somewhat interactive. So if people have questions or comments, they should be able to enter them in the questions tab in Zoom. So we'll try to get to those if we can, and depending on how many we have, we'll try to keep it interactive. I'm going to start with a brief overview of the regulatory landscape in the US, and then my colleagues in Paris will give an overview of what's happening in the EU. And at the end of the discussion, I'm going to go into what's happening in the US as far as legislation in the digital asset space. We hope to provide more presentations like this in the future, and keep this as ongoing collaboration, and to discuss issues for the regions that are the two largest investors in blockchain technology. So if after the presentation anyone has comments or questions or has suggestions for future topics, feel free to reach out to me or any of the other participants in this. So to begin, we wanted to have a quick survey on some of the different issues that have come up. So you should have a poll that has popped up, and it has two questions. And the first one is, what is the biggest obstacle to blockchain adoption in the US? And the second is, what is the biggest obstacle for blockchain adoption in the EU? So we'll give a couple moments, and if we thought this would be a good way to start the presentation to get everyone's viewpoint on what issues are really stopping full-fledged adoption of these technologies. Okay. Brittany, can you put up the results of the poll? So for the US, by far and away, it's the lack of regulatory clarity in the US. And that's probably expected. That is consistent with every single discussion panel that I have been on the topic within the United States, that is a major issue. And then for the EU, it's definitely more of a broad spectrum of different issues. There still is some issues with regulatory clarity, but the use cases and the difficulty in understanding and particular reputations have all been issues. So that is what we had expected. Let me go and now I'm going to begin with, everyone should see my screen again, a discussion on US regulation as it stands now. I will keep this as brief as possible, and if anyone has follow-up questions, we'll try to answer them. So regulation in the US of digital assets is complicated. At the federal level, regulation is handled directly or indirectly by many different agencies. I've identified a large number of them here, but this does not even cover every single different agency that is, that can have an indirect involvement with digital asset regulation. As a historical background, in the US, agencies were initially trying to determine if digital assets would be a substitute for currencies, and they were regulated in a way similar to currencies, where exchanges and brokers were treated similarly to companies like Western Union and registered as money services businesses. Around 2017, we really started to see the first enforcement actions coming in earnest in this space. A lot of them coming with the SEC's first actions related to ICOs, that's an initial coin offerings, where the SEC jumped in here because these were really being used for capital formation, which is kind of goes to the core of what the SEC regulates. As some may remember, 2017 kind of saw an ICO craze where numerous entities were trying to do coin offerings in an attempt to raise capital to develop ecosystems for the use of those tokens. Multiple enforcement actions have followed since then. The two primary agencies for the regulatory environment in the US for digital assets are the SEC and the CFTC. And this has been, having these two entities without clear boundaries between them has been problematic, because it's not always clear who actually will be the regulator, the first order regulator of digital assets in the US. Because the SEC, the way that they regulate securities is very different than the way that the CFTC would regulate commodities. And so this conflict between the two and lack of clarity has been, a core issue regarding the adoption of digital assets in the United States. So I'm sure many people here have heard the refrain in the US about the regulation by enforcement. And so that really goes to the SEC when we're talking about the regulation by enforcement. The SEC regulates securities, and it has a complicated and expensive set of rules to follow for the registration and sale of securities. The SEC has not put forward major rules on digital assets, but has filed numerous enforcement actions. In fact, the chair of the SEC, Gary Gensler, has repeatedly stated that he believes most fungible digital assets are securities and thus would be regulated by the SEC. But he never seems to identify exactly which ones are in that bucket of being securities. Confusingly, also, when he's making these statements, he always said he's not speaking with the full authority of the SEC, but those are his views only. This has opened up a gray area in the actual position of the SEC, as their leaders out saying that nearly all digital assets are securities, but the SEC is not taking a formal position on the issue. Of note, he has also refused to state whether the second largest digital asset, Ether, is a security. So here's what we know about the SEC. They have been very busy with enforcement actions in the last year. They have hired additional staff in multiple locations specifically for enforcement. They have indicated that more enforcement actions are coming if different issuers of tokens and exchanges don't come in and try to register with the SEC. As of now, they have pursued numerous enforcement actions against digital asset issuers, exchanges, and promoters. While they have, in these actions, they've laid out some of their theories, enforcement has been noticeably piecemeal in fashion. It is not clear how the SEC is choosing to bring complaints. Most that have had complaints filed against them choose to settle rather than engage in this costly litigation battle with the SEC. Of the SEC's currently pending actions, the Ripple case is probably the one that is watched most closely and is the most prominent. And currently, we're waiting a decision from the court in that case. I dislike trying to guess when a federal court will issue an action, or issue an order, but it looks like we should get something relatively soon, most likely in June. Some hope this decision in the case will be the first U.S. court decision actually stating that a specific token is not a security. The other cases that have gone to the court have already decided in those instances that the token issuance was a security offering. These includes the recently decided Library case, as well as Telegram and Kik. For exchanges, the SEC has filed against Bittrex, but in response, Bittrex's US entity declared bankruptcy and left the US. Coinbase received a Wells notice. So that's kind of a Wells notice, for those who don't know, is a preliminary statement from the SEC that, you know, an enforcement action is potentially on the horizon for you. Coinbase has publicly indicated that it will fight the SEC on this, and they filed a lawsuit asking that the SEC be forced to state whether it would make rules in the space. In response, the SEC has been non-committal and stating that it could make that it would make comprehensive rules according to its own schedule, if at all. And they even cited a case that said it was proper to take a decade or more to decide on specific rules. While the SEC has not made any big picture rules or on digital assets, they have been creating some rules at the edges of the space. You know, these include defining digital assets in the glossary for an update, or proposing to define digital assets in a glossary for an updated rule, which has been withdrawn at this point. They weren't even willing to define the term in the rules. And they also include changing the definition of exchanges to include DeFi protocols and changes to the custody rules. None of these rules, proposed rules, really address the big picture issue of whether a digital asset is a security, and if it is a security, how do you go about registering with the SEC? Furthermore, none of them deal with the fundamental issue of the jurisdiction between the SEC and the CFTC. I'm just going to hit upon two other regulators at this point, or two other categories of regulators that are important to US regulation. The first is OFAC, which this is the entity that's involved with sanctioning bad actors, basically, that use that perform money laundering or otherwise try to engage in channeling money to illicit activities. They have had some actions in the digital asset space. This, you know, the most prominent is the Tornado Cash sanctions, and this is an interesting one because in this, amongst other entities, they've also sanctioned a smart contract. This sanctioning of what people have been calling code has been challenged as being unconstitutional, as many have. It's been stated before that code counts as a speech, and therefore you would be covered under freedom of speech. Generally, this is interesting. OFAC's sanctions are typically not considered overly controversial because, you know, most people don't want to use digital assets, don't want digital assets to be used by criminals and terrorists and other bad actors. So, you know, to have this come in to the forefront was sort of interesting. And, you know, as I said, there's currently a case challenging this, the Van Loon case, as unconstitutional. Finally, I'm going to go into the three bank regulators in the US, the Fed, the OCC, and FDIC. They make rules that relate generally to banks and what banks have to do. They're most interesting because they have really prohibited, in general, banks from holding digital assets on their own books for themselves. And they do this based on something that's called the safety and soundness principle, which, you know, that's particularly comes from the OCC, where they need to make banks, they're in charge of making sure that banks are safe and sound. And they've said that holding digital assets on your books is against this, based on the current state of regulation and how the current state of the regulatory environment. However, there have been continued rumors that these regulators are also pushing banks away from offering services to digital asset companies in the US, such as for on-off ramps and just providing normal bank accounts for companies. Many have probably heard the term choke point 2.0. The first choke point, this is kind of goes back to what was called the first choke point, which was a coordinated effort by the federal government to limit banking for disabled industries such as payday lending. These were found to be illegal. So, some have seen echoes of that here, where these regulators are not specifically saying you can't do business with digital asset companies, but have at the same time there's been rumors that behind closed doors they're pushing away from pushing banks to go away from offering services to them. So just in conclusion, we have the impression that following the FTX's aftermath, and because the Congress in the United States is politically divided, regulators have been substantially increasing the number of actions brought against digital asset industry. This is likely because regulators can act more quickly than policymakers, particularly on centralized actors. But we really don't have full clarity at this point, and may not get full clarity until there is some sort of legislative action. There's a lot more going on. I know this was somewhat may not have seemed brief to some people, but this was, I think, a high-level overview of the most important regulatory actions within the United States.
Thanks, Chris. I think there is a question for you from my friend Tibad on the chat. If you can have a look on it. This is a basic question, if I may.
Yeah.
It refers not only to the Howey test and the fact that we don't have something similar in the EU, but would you please explain the situation in the US concerning the definition of a security, and specifically with the Howey test? Some of people are familiar with, but are not familiar with this test. It is not the only one, by the way, and it can be short to explain how a securities is defined or qualified by the Supreme Court and the various tests.
So first of all, securities are defined by statute. There's a 1933 and 1934 statutes regarding the definition of securities. Within this, there's a long list of different instruments that were considered securities. The one that is most important for digital assets is called an investment contract. It's kind of like a catch-all term. And so this has been, what an investment contract actually means has been set forth by something called the Howey test within the United States. So this has really been the point of issue for all digital assets, because this really is the term that encompasses digital assets in the United States and what the SEC is using to cover digital assets. So I don't have the full definition of securities, but for the Howey test, I want to make sure I get this right. So the Howey test has a couple different prongs, and first is just there has to be a set of money transferred. There has to be actions by a third party or a party to use that money for the betterment for a common enterprise. There has to be an expectation of profit for the investment of the money, and there has to be derived from the efforts of others. And so for Ethereum in particular, I think where the SEC seems to be hinting, and nothing is set in stone here, but is that since Ether went to proof of stake and can effectively gain interest, that this may have moved it into the security space under the Howey test.
Thank you, Chris. And we have another question, but before to answer to my other friend Philippe and my other friend Olivier, again, thank you to all of you asking question. Morgan, we have seen for some of the clients, French and EU clients, that this definition of US securities are quite important, specifically on DeFi. And this does the link, if I may, with the Philippe's question. Why it is so important to define securities for DeFi? And at the end of the day, what do we do in practice?
So I think that when we read the question of Tibad, and we understand it because we are French European lawyer, in Europe, we really focus on, the token, the asset, and from the qualification of this token, we can define and determine the regime that is applicable. In the US, it's very different because, as you said, Chris, you have this 4 prongs test, but the first element that for us is something very different in Europe is that an investment contract to be found, we need a contract, a transaction, or a scheme. So it's actually broader. You really look at the product and not just as the token. So that's the reason, for example, why Kraken, their staking service, was qualified as a security, because the whole way it was provided, with the involvement of Kraken in defining and deciding which tokens could be staked, which couldn't, it was really the way the intermediary interferes. And so the securities law, and I'm speaking under your control, Chris, of course, but is there to really reduce the asymmetries of information when there are someone that interferes and takes your money to invest them on your behalf and do something for you. So very broadly speaking. And so in that respect, it's very different from European law, where we really focus on the token. And based on this token, we can determine the regulatory regime. So the logics are very different. And it's much more about what the US intermediary does with your assets and how it commercializes also its products that are at stake.
Yeah. I was just going to say that, yes, I mean, in the US, they take a lot of information, ancillary information, into consideration for determining whether it's security. For example, if somebody gave a presentation saying like, hey, buy this token, it's a great way to make money, it's gonna skyrocket, that is considered, that language will be considered when it's determined whether it's a security or not just the actual functionality of the token or the coin.
And this is important, Morgan, for the DeFi, because we have a second and a third question concerning DeFi. The second is from Philippe, and the third is from Olivier. Both of them refers to the DeFi, but before to go to the DeFi, then we need to know whether or not it is a security. This is why, again, we come back to the security definition of security. Then, unless if I am not totally clear, for me, Morgan and Chris, there is not yet any definition on DeFi from the SEC or any other regulators. Then we come back to the point to see if it is a security, whether or not the security then is distributed to the public. But the first question for the DeFi refers to the definition again to the security, Morgan, no?
I think that's what is similar in Europe and in the US, is that when it's sufficiently decentralized, then you don't have an intermediary that can actually comply with the regulation. And so in the US, you have this that you will talk about later, Chris, this morphing theory that has been elaborated. Yeah. And in Europe, we are still, reflecting on what is decentralized, what degree of decentralization is necessary for the token and the scheme not to be considered as being regulated under current laws. So I would say that in comparison, we are maybe in the same path at this stage.
Yeah, and as far as this question of sufficient decentralization, that is a key issue as well in the United States. We'll go into that a little bit further when we discuss the legislation, but there was a speech by a SEC official that had put forward this in the United States as well in 2018. But it's never really been defined by the SEC, and nobody really knows when it actually happens. There's just that's kind of goes to the core of the lack of rulemaking on specific issues.
For the third question from Olivier concerning personal and territorial clues, I think we will come back later on, Morgan, when we will discuss the OOP case, or when we will discuss in more details, Olivier, if you accept. Except if there is any more question, I suggest Chris to move on to the next part, which is ongoing legislation in the US.
Yeah, because I think we all wonder, because we understood that the regulatory framework is quite fragmented. So is there going to be comprehensive legislation on crypto assets in the US? What is going on?
So for US legislation, there have been discussions, ongoing discussions. So I guess what I would just say right now is there's many proposals, but nothing is final at the moment. This has been the case for several years now with multiple proposals put forward. It's actually can be quite confusing to follow all the different proposals that have been put forth by different parties. The one that really has been gaining traction and was pretty close to a deal last year was the issue for payment stablecoins. There's another bill in the works for that that has been kind of taking up a lot of the time and discussions within Congress, and I'll go through some of the specific provisions. The House of Representatives in Congress has really taken the lead in pushing the discussion in the United States for legislation. At this point, there had been previously some action in the U.S. Senate, but that kind of really they haven't done much. So previously there was a bipartisan bill by Senators Loomis and Gillibrand, which was, discussed quite a bit, but they really haven't been continuing to push that one forward in recent days. And the action has all been in the House, who's held numerous hearings with several discussion bills introduced. So just stepping back and seeing how we got here, I'm sure everyone else here is aware of everything that happened with FTX, but and many probably know that Sam Bankman-Fried was also a prolific giver within Washington and gave a number of donations to different members. I think this has really put a cloud over the legislation near term, and so it caused people to really pull back, I think, from the current discussions on legislation. The bill that he was proposing and pushing was some had labeled a DeFi killer for applying to DeFi protocols, compliance rules for the same compliance rules as centralized exchanges. That bill is dead, obviously, after the FTX implosion. I would say generally, as a general statement, this caused what was a bipartisan issue previously to become more partisan. And we're seeing a lot of more Republicans that have been friendly or at least neutral to the digital asset industry, but the Democrats less so. And I would just say, for the Democrats, generally, if you are vocally anti-digital assets, you're probably a Democrat at this point. You see that in a number of the different hearings. So this is just a description of the House of Representatives agenda for digital assets. They are, like I said, they're going to be holding a number of different hearings over the next 2 months. They've already held a number of them. What they put forth as the primary questions to discuss were whether digital assets are securities, the CFTC's jurisdiction for digital assets and recent case law suggesting that virtual currencies are commodities, and the risk due to inaction by Congress to regulate digital assets and continue regulation by enforcement. This is the past House schedule for the hearings on digital assets. All but one includes the Financial Services Committee, which is a very important committee in the House. So it's notable that they are spending so much time on hearings, because they don't always have so much time for hearings. One hearing was on the environmental issues related to digital assets, but I haven't seen much discussion further about that. This really shows that they are, at least in the House, they're taking this seriously, and they're really going to be working on potential legislation. So I'm going to go through just kind of what was discussed at some of these hearings. And so the two broader focused hearings, the discussion showed that there's still some fundamental disagreements on the initial step to be taken within the US, and there also is not a consensus on how the broader problem should be addressed. There was a number of different options discussed at the hearing. Some still seem in favor of a broader, more comprehensive MiCA scale law, and others seem to advocate incremental changes working towards regulatory clarity. Some of the options for incremental changes include, just direction from Congress and to requiring that the SEC and CFTC make joint rulemaking, setting up guidelines for what's called self-regulatory organizations, SRO, to really watch the exchanges. What they have kind of put up for as the different problems are concerns that, if we don't regulate now or offer legislation, companies in this space would offshore and the US would fall behind as they continue what they are. And there would be a potential loss of innovation in the US and make consumers less safe, because now more companies will go to more lightly regulated areas. And, the US consumer will presumably find, even if they are not specifically allowed to use that, would, through VPNs and other aspects, could use those services. There was also concern that if digital assets were provided an easier disclosure regime in the United States, that all of a sudden all securities would be, would be trying to classify themselves as digital assets to not have to deal with the more onerous regime. It's also worth noting that at the April 27th hearing, there was a witness that actually advocating for making digital assets illegal in the United States, saying that they really serve no purpose. Thankfully, this really was not expressed in the May 10th hearing, or at least everyone on the panel agreed that digital assets have a right to exist. One proposal was to set up minimum standards to prevent fines or shut down for exchanges. These minimum standards would include providing information on reserves and preventing conflicts of interest. A token could still be considered a security, but at that point, it would just need to be delisted from the exchanges. It was also argued by some of the panel that there's really no rush to go with a law until we understand fully the consequences. And they had advocated this incremental changes with a safe harbor, where, as long as you meet some minimum standards, you would be in the safe harbor, and they could later change the rules, but you wouldn't be able to get penalized by the SEC or the CFTC. Finally, there was a lot of discussions about making the CFTC have authority over the spot market for digital assets. Currently, the CFTC can only regulate fraud and manipulation. It basically is reactive. It determines, if something bad has happened, then it'll look into it and try to go back and correct it or fine or take the bad actors off the market. But it doesn't really have this proactive regulatory framework in place where it can, look at the, setting standards and reporting requirements before something bad has happened. So there was a lot of discussion on providing the CFTC that authority. One of the other big issues was that the CFTC is a much smaller agency than the SEC. It has about 700 employees, while the SEC is about 6 times that size. So there's a lot of concern that it really wouldn't have the ability to regulate this market. So there's a lot of issues still being discussed for a comprehensive response to the issue. And given the major differences in how they approach the problem, there still needs to be a lot done in this area. I wouldn't say I am too optimistic for a comprehensive bill at this point, just given the wide range of different options that are still being considered. Just one last point is also that the committee has also asked the SEC to turn over documents regarding who has actually attempted to come in and register as a security. This has been another reframe from Chair Gensler, where, just come in and talk to us. Like, we're willing to work with you. And, the House is really wanting to look into how possible this actually is. Okay. Oh, sorry.
Yeah, please go ahead,
sorry.
Chris.
Yeah, sorry, I had one last slide I forgot about. So let me just.
Because I think it is interesting to show what you have prepared concerning the Securities Clarity Act.
Yeah, so I'll continue with that. Okay.
And then we can move on maybe to be quite short on this act, but if you can share, your screen, and we will move on to EU and then come back.
Yeah. So I was just going to mention also, I think I had alluded to it earlier about the Senate. The House is only half of the legislative body in the United States. So the Senate is also known to be the slower body, and they really haven't done much in digital assets. There's a real concern that it's just not a priority to them, and that something won't get done, really not because there's consensus, but just because there's just not enough time in the schedule to do it. Like I said previously, Senators Loomis and Gillibrand had introduced a bipartisan bill, but they haven't really followed up on that. They had said in March that they were going to release another draft of it in April and have not. But there's been some rumors that they're continuing to work on that bill to make it closer to what the Republicans in the House have presented or are intending to present. As many have probably seen, Senator Warren has come out strongly against the digital asset industry, saying that she wants to make an anti-crypto army, but nothing seems really to be coalescing around that movement, and I haven't seen much from her on that point recently. So I'll just go into this next. This is as far as specific legislation that's been proposed. One that has bipartisan support is this from Representatives Tom Emmer and Darren Soto. This was a bill that was previously put forward in 2020, but now has been put forward with some bipartisan support. And it's a short bill, but it goes to kind of to this, in some ways, directly to the kind of the key issue of, this sufficient decentralization. And so this, so the bill is intended, to the idea that just because something was originally sold as security doesn't mean that it's always a security. Instead, it shows that a token can change from a security to a commodity if it is decentralized. This idea was put forward by the SEC Corporate Finance Division Director Hinman in 2018. According to this approach, where a blockchain project is sufficiently decentralized, the crypto asset associated with the project will no longer be seen represent an investment contract under the Howey test. This theory has led Hinman to say that he didn't believe Ether was a security at the time of his speech. But this, again, this test really has a lack of clarity on, at what point there's sufficient decentralization. It's actually a very difficult question to answer, at this exact point when something goes from not being a security to a security, and it's really never been tested before. So the Security Clarity Act goes to this and really tries to say that these are two different things. So I have here some of the language, the proposed language from the Act, and it just kind of states here that, that we have endorsed that an asset underlying an investment contract, for example, the Orange Groves and Howey, are the actual security. And then also, it goes to the fact that they believe these two issues have been conflated, and that, this kind of putting these two together and not distinguishing them has discouraged development of digital asset sector in the United States and hindered innovation in the industry. So it's really not clear at this point how much support the bill has. I mean, like I said, it's been introduced in the past. It is interesting that it has bipartisan support at the moment, but the hearings that I've watched have not really discussed anything this specific, or shown that there's broad support for it. But the fact that it does have sponsors on both sides of the aisle is interesting, and does show that maybe it may have more support this time around. So, did you want to add anything?
Yeah, very interesting. Thank you, Chris. And we are wondering, because we know that the US have had an eye, on stablecoin issues, especially since, the Terra USD collapse. So do you know if there are anything, in the pipes as of today for the stablecoin questions?
And if concerning the stablecoin, which is quite sensitive, not only in terms of regulation, in terms of politics, is there any debate between the Republican and between the parties, to be short, the Democrat and the Republican? Is it a political issue? Is it more technical issue? Because here in Europe, it is more, a technical issue. The debate is more, let's say that, led by the ECB, but we don't see any major discussion between the left and the right side of the politics, if I may.
Yeah, it has somewhat become a political issue. It seems that both sides agree that a payment stablecoin bill is needed. I've seen at the hearings, there's been both people on both sides saying that, hey, we really hope that we can work out an agreement here. And both sides have said we're not that far apart on a payment stablecoin bill. There's been 2 hearings on it. And so the first hearing, there was a bill circulated by the Republicans. I think they had understood that to be kind of a bipartisan bill. The Democrats have come back and said, no, this is really won't work anymore. This is the old way of thinking pre-FTX. And so there was a lot of pushback, I would say, from the Democrat side on that particular bill. I won't go into great detail on it just because it's already been withdrawn by the Republicans, but I'll hit some of the high points, which it put the Federal Reserve in charge of most of the aspects, had a two-year moratorium on new stable coins. They're not backed by fiat and required a study of central bank digital currencies. So at the May 18th hearing, which was just last Thursday, they actually went into more detail on 2 new laws. And so this time, both the Republicans and the Democrats put up bills. And so it was a lot of shared language, but the structures were different between the 2. Statements of both sides, said that they hoped they could agree to something and pass a bill. One major change was removing the possibility from the first bill was removing the possibility for non-bank stablecoin issuers to access the Federal Reserve, which was a big contention. The reason given was kind of to insulate the traditional banking sector from the digital asset space. What is being discussed as the main difference between these 2 bills, as I've said, the structure is very different between the 2, but the Republican bill allows what's called state qualified stablecoins to be issued, which just means the stablecoin needs to get approval from their state regulator. They don't need approval from the federal government to offer a stablecoin. The Democrat bill takes away this. You can be state qualified, but you still need to, within a period of time, register with the federal government. And this was brought up numerous times at this May 18th hearing, that the Republicans want this state level authority to issue, to regulate individual stablecoins, while the Democrats didn't discuss it as much, but they did indicate that they wanted broad oversight from the federal government. And they were concerned about this type of race to the bottom, where the states would compete to have the most lax regulations to draw stablecoin issuers. And the counter argument to that was that there are in both of them, they're federal backstops. So there's only you have to meet certain requirements in both, and even the Republican bill, the federal government can jump in if there is some sort of catastrophe in the industry. Just with 48 hours notice, I believe they could jump in on what they call extingent circumstances. And the parties do also seem to have just an ideological difference between CBDCs, and Republicans do not want that. They think that gives too much power to the federal government to track the spending of individual dollars, while the Democrats have put that in their bill, that they want that to be at least researched thoroughly. So these were the major issues that were discussed as the concerns, which is for the stablecoin bill, which is offering consumer protection. There was a lot of discussion on maintaining the US dollar supremacy as the world reserves, and whether issuing stablecoins in the United States would actually help this or would hurt this. There seems to be both positions were kind of discussed. And also just not, the common refrain in all this legislation is just not falling behind other countries and areas in the world that are being more proactive about regulation. So
I'm just curious, because the time is quite running. Can we, because the slide will be sent to the attendees. May I suggest, because we have planned for 1 hour, it's quite running now,
Yep.
to move on quite quickly and to have few minutes on the EU side, and maybe to come back after to you.
Yeah, that is perfect. I was just going to say there's a lot of shared language, and I was going to go through some of the different language, but yeah, we'll yeah. Why don't we jump to the EU side and see how you guys are handling it?
Thank you, Chris. Again, which is interesting to see in your presentation is behind the scene, if I may, there is a lot of proposal from the Congress, and because here from the EU, we don't follow on a day-to-day basis what happened in the US, and we just see what happens from the SEC, potentially with the CFTC, and we still focusing on regulation by enforcement. But what we see, thanks to you, is okay, but behind, again, the scene, there is various bills to be discussed to the Hill, and potentially in the next months, maybe year, we will have one of those bills voted by the Congress, which is quite important, and specifically on stablecoin. Victor and Morgan, if we move on the MiCA, we will not repeat what the MiCA is supposed to regulate, because most of our attendees are from the EU and they are supposed to know. We can maybe just discuss on what is the next step for the MiCA, and specifically in terms of timeline and in terms of RTS. I will maybe give the floor to Victor to go directly to what is the situation in terms of ongoing process for the MiCA, and to illustrate with the RTS, Victor.
Yes, yes, thank you there. Thank you, Chris. Can you see my slides now? Yes, okay. So, of course, MiCA is 500 pages long. So this is a regulation which is extremely detailed and covers a lot of topics. So, as you were saying, we will not be describing MiCA like part by part, because most of you already know it. We might start with, since we spoke about stablecoins, something we could discuss like right now, because it's extremely important.
I can't hear you very well, Victor. There is quite close to the micro.
Okay, sorry. So stablecoins are like half of the MiCA regulation, since in particular the MiCA regulation was prepared after Facebook 2 years ago announced that it was working on Libra, its own stablecoin. So preserving the monetary sovereignty of the EU, so with the euro and also of other member states, was a core focus of MiCA. So stablecoins are subject to a quite detailed and also quite restrictive regulation. And it's very interesting to try to compare that regulation with the proposed regulation that the US could have in maybe a few years, because the path that has been chosen in Europe is already very specific, and probably will not be seen as an example in all the other jurisdictions, which is very interesting, because in MiCA there are two categories of stablecoins, the electronic money tokens and the asset reference tokens. So the mere fact that there is this distinction is already quite interesting, because of course most stablecoins as they exist today would be seen as electronic money stablecoins because they refer to one official currency, but MiCA has dozens of articles dedicated to asset reference tokens, which could be any kind of stablecoin which references something else than one single currency, like commodities or basket of currencies. And what is very interesting is that stablecoins are restricted by the MiCA regulation. This is something that is not completely understood, it seems to us, or at least not up to now, because many people seem to think that because MiCA creates a possibility to issue in a regulated way stablecoins, it means that stablecoins will be able to be used very broadly, at least in the EU, after MiCA becomes applicable. This is quite questionable. There is a lot of provisions in this regulation that would enable the European authorities and also the European Central Bank to restrict the use of a stablecoin as a payment system. And this is very important to understand because it is absolutely certain now, from what we have been able to hear from regulators, that MiCA is not meant to encourage the use of stablecoins as a payment method. Authorities will have many ways to restrict the use of stablecoins once they reach like a certain threshold. Like if they become significant and they become used in many European countries and represent hundreds of millions in volume, they will be subject to additional supervision that will probably mean that they will be restricted in a way or another. So this was the main point that we had about stablecoins. And it's quite interesting. So this could be a question for Chris. Is there in the US that similar kind of approach to stablecoins, which is like, we will regulate stablecoins, but also make sure that the regulation is so restrictive that stablecoins cannot be used to create a payment method?
One interesting point, Victor, is if I am correct, because the idea was to discuss on the next step on the MiCA, and one of the next step after the publication to the official gazette, official journal of the EU, will be the draft of the FTS. And if I am correct, because as you know, the two EU committees, the EBA and the ISMA, will be in charge to draft those FTS, and specifically concerning their respective jurisdiction. And if I am correct, come back here, Victor, it is better to hear you. This is good to be in the same office, not in the same room, but in the same office. Well, I change, if I may, my neighbor from Morgan to Victor. Just to let you know, we are in the same office. Voilà. Victor, can you tell us a little more on the first meetings that had been
Yes.
a few days ago on the EBA concerning the stablecoin?
Yes, so there is in MiCA a specific and more restrictive supervision for what is called significant stablecoins, either electronic money tokens or asset reference tokens. And when a stablecoin is considered significant, it will be subject to more restrictive rules, specifically regulation directly by European authorities. And this first meeting, organized by the European Banking Authority, was meant to discuss, so organized by the Banking Authority, and with a lot of participants from the ecosystem, including stablecoin issuers like Circle. And it was meant to prepare and propose to the ecosystem the first criteria that could be used by the regulators to determine what kind of conditions would make a stablecoin significant. So there are a lot of conditions that were discussed, like quantitative measures, the use for cross-border payments, the volumes, the integration with the payment service providers in several countries. And all of this is starting to be discussed at the European Union level and between the authorities and the private sector.
Voilà, and this is the time now, maybe for you, Morgan, to come back to in our presentation. Sorry to jump from one slide to the other, but maybe where are we today on the MiCA, and maybe to explain because a lot of people they think that after the MiCA publishing on the Journal official journal, it's done. No, it is a new way of regulation. What does it mean? What are RTS? How does it work? What is in practice the next step for people? Because there is a lot of RTS. What does it mean, RTS first? How does it work, Morgane?
Sure. Can you hear me?
Absolutely.
Okay. Talking into the microphone. So MiCA is the framework. It's the global framework that just sets out the global rules that will apply with respect to crypto asset service providers, stable coins, and all this framework. And so now we will have the second level of regulation, which are called the regulatory technique standards, which are the RTS. And so for each rule, or for most rules under MiCA, there will be an RTS that will provide clarity and definitions, and which will really detail the rule. So, for example, under MiCA, you will have a rule for custodian that will say, okay, if you are a custodian, you have to segregate the assets of your clients from your own assets. But then the RTS will go further and will actually detail more about eventually the rights, how the rights of the clients on their assets, how the custodian is really supposed to, provide security to the custodian infrastructure. So it's going to go into much more details. So as of today, MiCA has been voted, and before MiCA enters into application, the RTS are supposed to be voted and implemented. And so as of today, we are still, we know that the European regulators are, discussing about which RTS are more should be treated in priority, and they will actually call for the industry to eventually provide information and their opinions on what should be the rules. So this is to come in the following weeks/months.
And this is maybe one of the important points, is because there is place for the industry to discuss and to be involved on the RTS process, because RTS process is not only a process, is not an internal process of EBA or the ESMA. Of course, they will decide at the end of the day, but it is an interactive discussion with the industry in a form of in a two form, if I may. The first form is some expert can be appointed by the EBA or the ESMA as an expert to participate, to attend to the discussion on specific RTS. And globally speaking, all people can comment on the RTS when the RTS are published for discussion and after a public consultation. And there is two ways. The first one is very important. Some of you can be interested to be designated as an expert, and it is time to see on the EBA or on the ESMA website how can you be designated as an expert, because it is possible. And then, or if you don't want to be designated, if you have no time, then you have the chance to comment on the consultation process. There is 60 RTS to be issued, which is quite huge, specifically because some of them are more urgent than the other, those concerning the stablecoin, because stablecoin will be enforceable on the MiCA 1 year after the publishing of the regulation, and more or less in May or June 2024 now. And the EBA and the ESMA will have few months to prepare those RTS. Any comment, Morgane or Victor, on this topic?
Yes, so first, a quite important comment. The EBA at least clarified that there will not be a public consultation on all RTS. Some of them will be published without a public consultation, or only with an informal consultation of some actors of the private sector, because they have no time and they have not enough resource to prepare all that they have to prepare before next year. So consultation might be limited to the most important RTS or a batch of consultations.
Voilà, Morgan, any comment on it, or maybe do you have any?
Yes, and so the industry is already getting prepared because through the associations, especially the ADAN, there are already propositions and positions that are being pushed, prepared.
Okay, time is running, Chris, and it is 7 p.m. Paris, if I may. If you maybe have few words to conclude, what is the situation in the US concerning this situation? Because, okay, what is the chance to see a regulation in the US concerning both a definition on securities and or a stablecoin in few months? Is it something which is reasonable or not?
Yeah, I think the stablecoin bill for sure is possible. I would say broader. I haven't seen anything to indicate that a broader bill or a more bill that goes to the core issue of when a digital asset is security is likely to come about. But people are paying attention. People are doing work on it, particularly in the House. So I am cautiously optimistic that maybe in some time frame it will get done.
Okay, good. This is a good news. But concerning the definition of securities, we need to wait. We have to wait.
That's correct. You never know, something could pop up, but the fact that they haven't proposed coalesced really around any standard or any particular law just doesn't give me hopes that it'll happen anytime soon.
Okay. If I am correct, Chris, we will send not today, but potentially tomorrow, if I am correct, to attendees the slide, which are more specifically, which are more deeper than the presentations that you and us have provided. Let me thank you again, Chris, for the time, because it is 9-hour time difference between LA and Paris. Quite early for you. Now it's less early, if I may. It's quite late now for us, if I may. Thank you so much. If I have seen some questions on the screen, we have no time to discuss all of them. We tried to do it. Thank you to Morgan and Victor. Thank you to Britney. Thank you to all of you. If you have any question, as Chris said earlier, please feel free to contact any of us on this presentation. Well, Chris, last word for you.
Yeah, thank you. I just want to thank everyone for joining us.
Thank you. Thank you. Have a nice evening. Goodbye.
Bye.
Thank you.
Thank you.